But so our guest is Ryan Carson. I'm so happy that he could come, and he's helped me out with a couple of projects. So, and I thought it'd be good that he come, and well, I guess we'll start with Ryan. Do you want to tell us a little bit about yourself?
Sure, thanks, Diana. Hi, everybody. How's everybody today on a Saturday morning?
Hi, great, thanks.
Thank you. I'm a lawyer, and Diana, I do invest myself as well, but volume-wise, I stick mostly to my law practice at this point. Most of my investing is just in some private lending at this point, and being money partner on potential BRRRRs or rent-to-owns. But most of my personal investing is with private lending at this point. Just something I prefer and just enjoy more than the other. But I've been a lawyer for just under 15 years. I think it's about 13 and a half at this point. Originally, I started my career as an associate with a firm in the Halton area, and was there for just under 7 years. And then I switched out, created my own business, Carson Law, and I've been running it since 2014. So again, just under about 7 years with that. So I mean, Carson Law basically has grown from just me as the sole employee in 2014. We're up to about 25 people now. There's 4 lawyers, the rest are clerks and assistants. And we work predominantly with real estate, corporate, business, wills, estate planning, administration, and we do intellectual property as well, which are patents, trademarks, copyrights. And we're just launching this year a paralegal service, which is landlord tenant, small claims, provincial offenses, tax court. So we're working on growing. Everybody else, who's in business or a real estate investor, have goals every year, try to grow, not too fast because it's hard to manage if you grow too quickly. So we try to manage our growth and strategically just project out and hit those targets, and then we move on to the next. And it's myself, like I said, and a team of 4 other lawyers. We've got 3 students right now, which will hopefully turn us into about 7 lawyers in about 3 or 4 years' time. And we'll just continue to work on trying to grow. I'm not sure where Diana and I first met. I can't remember now which real estate investment group it was through, but we do a lot of work with Oncom, REI, REI Club. So those are the different groups that we've been working with over the last couple of years, doing some various sponsorship and speaking and presenting at. So you may have seen myself or our company at some of those events if you're part of any of those groups. And in the last couple of years, I'd say last 2 or 3 years especially, we've really started to work quite extensively with a lot of real estate investors. As everybody on this call is probably aware, real estate's a very fast growing, popular means of investing, especially with the hit that's happened in obviously the economy in the last 3 to 4 months. Stock market is pretty dreadful at times. So a lot of people are turning to real estate for, investment, return on investment, security, a bit more of consistency and control, really, because it's private typically, and you can make your own, you can kind of make your own terms and your own rules on the investing side, right? So we work with a lot of investors. We help investors with the transaction side of things. So if they're buying and selling, if they're doing wholesales, if they're doing private lending. So we actually do the registrations and the transactional documents of that type of transaction and file. And then we help people also who are real estate investors who are seeking corporate structure. Typically, we get our clients to get tax advice from a tax accountant, especially one experienced with real estate investors. So we set up corporate structure, family trusts, partnerships, shareholder agreements, and JVs. So we've worked quite a bit, like I said, in the last couple of years with real estate investors on probably almost all types of real estate investor deals that you would be taking part in or familiar with or aspiring to. And unlike probably some other real estate lawyers that are out there, like I said, we are real estate investors ourselves, and we do understand what you guys are trying to do. So we're always going to try to help you. And if it's something that's completely novel and new for us, then we're excited for that opportunity, and we're excited to try to learn what you're up to. So that's me in a nutshell, I guess.
Mhm. Well, that's great to know. And it's always great that you're willing to evolve with changing times, because that also sometimes becomes a problem where some people are just want to stick with what they know and that's it. And sometimes, especially like COVID is a very good example of that's probably not a good idea, because a lot of changes are probably going to start happening.
Yeah, absolutely.
So, yeah. So I guess let's start with a very basic question and just what are JVs, what are shareholder agreements, and like what are the differences?
Yeah, no, great question. So a shareholders agreement, I mean, both the JV and the shareholders agreement um, are fundamentally legal documents to set out the rules and regulations and how parties are going to operate in some sort of business arrangement with one another, right? The shareholder agreement specifically relates to shareholders that are owners within a corporation. So if you were setting up a corporation and you had other people as owners with you, those other people would be other shareholders. And those other shareholders and you, as owners of that corporation, would want to enter into a shareholders agreement. So that's basically what a corporate group of owners would call their partnership agreement. So the shareholder agreement is going to set out these are all the people that have ownership in the company. These are how many shares they own. This is how much each share was. These are the characteristics of the shares. Are they voting? Are they non-voting? Are they preferential? Are they non-preferential? Those sorts of things. They'll set out who sits on the board of directors, who's officers of the company, how you vote in officers, directors, how you have to have a shareholders meeting, how you have to share your financials. And then ultimately, probably the most important part of the shareholders agreement is going to be if stuff isn't going well between all of you, or one person isn't getting along with the other group, how do people divorce from one another, basically, from a business standpoint? How do you separate out without it being a huge mess, without there being a lawsuit, without it being a problem that stalls up the business's operations? So that's really probably the most important part about the shareholders agreement, is that those exit strategies, those exit clauses, right? Some of the common clauses that you might hear out there in the industry are shotgun clause is one, right of first refusal. There's sometimes minority shareholders, meaning they hold less than 50% of the shares. So there's some minority investor clauses as well that can be added. They call them drag along, piggyback clauses, that kind of thing. So those are clauses that help with determining exit strategy and how to have like a business divorce, so to speak. The joint venture agreement, on the flip side, is a partnership agreement, but between established businesses. So you don't effectively have any ownership over each other's businesses, but you agree that in common you're going to work on projects or a project for a set goal, a common goal, and then in return, everybody agrees in the joint venture agreement, these are the responsibilities of party A, party B, party C, and these are the return on investments for those party A, B, and C. So that's very briefly the difference and what each of them are. Obviously, you could get into much more detail, but you probably have some other questions as well.
Yeah, thank you. And so then if we're going to be writing let's say a JV, uh,
Mhm.
what would you expect us to think about and be prepared? What kind of questions should we ask ourselves to at least get a little bit started? Because I'm sure you would ask us some questions, but just some questions that we should kind of mentally prepare for and ask ourselves when creating a JV agreement.
Yeah, and we've got we've got a precedent framework, sort of like a questionnaire that we go through with our clients to just at least get it started. But I mean, it does more than just help get it started. It'll help flush out a lot of the details that we would need for the JV. But it's questions like, who are the parties, who's all going to be a party to the JV, what are their roles, what are their responsibilities going to be, what financial and investments and inputs are people putting into the JV versus, um, if you've been doing this for a while, then you'll probably have heard the term like money partner versus like management partner in a JV scenario. And so, money partner, as it would suggest, typically puts in money, and that's their kind of sole role in the JV. Whereas the property management partner is the one that's basically, coordinating with trades if there's a reno, coordinating the tenants, coordinating with the tenant buyer if it's a rent to own, just managing any day-to-day and everyday problems of the property. And then typically you'd have also in that JV agreement those like divorce clauses, just in case something does happen and stuff hits the fan and you can't coexist anymore in the middle of the JV term. A term is typically somehow fixed in the JV. So sometimes there's like a set date and it's very simple and it's the JVs for 5 years. And so it comes due on this day and we have to sell the property on this day. Or some other times it's a little bit more of a fluid formula where it says the term is for the term will be no fewer months than 6 months and is wrapped up on either the refinance or the sale of the property by the parties. So it can be something that's a little bit more fluid like that as well. And then we typically also with the roles and responsibilities recommend to make sure all the parties like ROEs are kind of in the agreement as well. Like what, as much as you can, flush out what are people expecting their rate of return to be. What's the return on investment here that you're expecting to get? Is there a set formula for it? Is there a set number? Is there a set number plus one? So those sorts of things we try to flush out as much as possible. I think the most important thing with drafting the JV agreement is two things. One, be as clear as you possibly can in it on who's putting what in and who is expecting to get what out. And then the other thing is make sure that you have a very definitive, I'll call it problem solving set of clauses. So if there are problems, the partnership starts to go down the wrong path, there's an easy way for one partner to close off that issue and buy out the other partner or close off the partnership to make sure that, number one, you don't want to damage your reputation in the industry of real estate investors, and number two, you don't want to have your deal get bogged down or scuttled or ruined because of an internal feuding with your partners.
Makes sense. So does anyone have any questions that they would like to ask? Yeah, go ahead, Alex.
A quick question, because I've heard different things about how to put up the JVs, and I heard some people say that you could just write on a quick piece of paper the agreements between you two and have both of you sign it. At what different levels should you like just do something like that, or go to like a lawyer to yourself to fully write it properly? Do you find there's different situations, or just always just go to you basically?
Yeah, no, it's a great question. And you know what? It's really hard to answer that because you can find some really, you've probably been to some real estate investor seminars and speaking engagements where, very well off and very well to do real estate investors are like, I've never had a JV in my life. I do a handshake deal and that's that, right? Or, you know, I scribbled our terms down on the restaurant napkin and that was our deal. I would probably argue that those people have been very lucky. Their days probably are numbered. Something will probably come along that will eventually be a problem for them. That being said, you know, do you need a 100-page document drafted every single time by a lawyer? Well, probably no. Our precedent JV agreement, trying to go, I go off memory here. I think it's around a dozen pages or so, plus or minus. So, and we try to have it drafted in plain language. You know, we don't use a lot of legalese and Latin and all this kind of crazy stuff that, you know, is more common in like older legal documents. The profession as a whole is trying to make documents very plain language. So you don't need a lawyer maybe to read it. You might need a lawyer to ask questions and just, you know, make sure you're understanding what you've read, you know, a second opinion, so to speak. But you know, we try to make our document set up so that it's, you know, it's relatively a plain read, although not plain in the sense that it's incomplete on what it would protect, right? The idea is let's get what you want out of the JV. Let's get what your other partners want out of the JV, and let's flush it all out. Let's make sure it's in a document that at the end of the day, if stuff does go sideways, everybody just points to the document and says, okay, well, this is what we agreed to. So I actually am not right, you know, or, you know, we can't get along anymore. So let's go to this clause and, you know, this is how much you have to pay me to get rid of me. And everybody agreed to it up front when everybody was happy and in a good mood and wanted to be partners. So it shouldn't be a problem. You have to live with those terms, right? Both parties do. So, I mean, I don't really know that, hey, sorry, my dog's barking. So, I don't really know that there's a direct answer for you of like, okay, this type of deal, you don't need one, and this type of deal, you do need one for sure. I don't really know that kind of scenario exists. It's really your comfort level, the comfort level of your investors, and I guess complexity of the deal, right? I guess the short answer is I would probably have one on every deal because I'm a lawyer and I'm conservative and I want to make sure everything's out there and agreed to. And, you know, sometimes it's going to be maybe in my favor what the JV says as one of the parties to the JV, but in other times it might work against me, but I agreed to it. I knew about it up front. And so those are the terms, and that's the way we go forward. I mean, I think the greatest good that you can get from having a JV and having it well written in ahead of time, not just on a napkin or a piece of paper or something like that, but, you know, using a lawyer, because now everybody's had independent advice. So nobody can say, oh, well, I didn't really understand this, right? There's accountability. Hopefully there's accountability and there's certainty to now a situation that doesn't have any of those because, you know, you're fighting with your partner or something. So it's really about the JV is important because create accountability, create certainty. So when stuff does hit the fan, there's no way people can turn around and try to backpedal and try to change the way it should be. It's there, it's in writing, everybody agreed to it up front, everybody had independent advice by a lawyer. And yes, that could be a bit more kind of an expensive process than just kind of writing it up yourselves. But again, creates accountability, creates certainty, it creates less excuse for somebody to say, well, I'm not agreeing to this. You know, that's not what it said, you know, and even if that's what you think it says, that's not what it says. And that's that, right? So I think it's the answer I would say is it's always good to do a JV, always good to have it done with lawyers because then they've got that ILA, that independent legal advice, and it doesn't need to be expensive, right? I mean, I guess that depends which lawyers you go to, but I mean, because we work with real estate investors and because we do so many of these, we've got it kind of systematic now. You know, we've got a precedent that we've built on, that we've tailored over the years through both good and bad experience. So we kind of know what people are going to want and ask and want to have in there. And then there's always a couple things that are deal specific that we need to edit and tweak, of course. But overall, I would encourage you to always use JVs, always use lawyers with it, because it creates that accountability and certainty. And like I said, it doesn't need to be expensive. Like our cost for a JV to be drafted is it's $1,500, which I guess $1,500 is $1,500. It's not nothing. But it's certainly a lot less than going to small claims or going to court, right? Superior court, you're going to be paying probably like $5,000 retainer for something like that. Plus now you've got a ruined relationship with a possible, real estate investor, right? So,
and also though you could probably, like normally I think a lot of us will probably start picking out our niches. Oh yeah, no problem.
Sorry.
No problem. But so most of us, I think, like sooner or later, we'll probably start picking out our niches, and we could probably also just have a JV template created where we have some blanks that we fill in. And like, would that still need to go to a lawyer? Or if we have the lawyer, for example, create the contract and make it reusable, like it's not also so expensive, I guess, because it's really a one-time fee, unless if in the future maybe it does change, then maybe we change it again, right?
Yeah, like, so again, everybody's gonna have their own comfort level. I mean, a good thing, I think what you're suggesting, Diana, is we could, get us involved to do your first JV. And then if you're gonna have the same partner for a couple projects in a row, or a very similar type of project repeated, but with maybe a different partner each time, I mean, you could certainly use the document that we've done the first time through, and you could do your own edits and reapply it to your different deals. I mean, I think I would still go back to, it would be good to get lawyers to do the independent legal advice, even if you've done all the legwork of getting the agreement together. I mean, ILA is typically around 250, 350, plus HST. So again, that ILA would still be good, because then, neither party can say, oh, I didn't have a lawyer, or, I didn't understand this, or, they avoid having that kind of excuse, right? So even if you paid the investment, and I think that's a good way of looking at it, don't think of it as like, oh, I'm paying a fee, look at it as an investment, because you're doing real estate investment, obviously, to create a primary or secondary income source. So use the lawyer and the accountant and any of your other advisors as an investment. Get a lawyer on your payroll that is good with real estate deals and investors, which we'd be happy to do. And then what we do is we'll do a precedent JV agreement for you. You make that investment the first time at the $1,500 mark, but then in the future, if you felt comfortable kind of making your own edits and then just doing independent legal advice each deal at a time, then your cost becomes lower, right? But you still have a proven document that was written by a real estate investor lawyer. You do your tweaks where you want to tweak it, and then you had ILA, so nobody can turn around and say, oh, I didn't understand what this said, and I didn't have a lawyer. So I think that's a way you could approach it too.
And what's an ILA?
Independent legal advice.
Oh, that's the independent.
So what you would do, if I understood your and Alex's kind of suggestion, we do a precedent document, get it all done up for you, maybe on your first deal, or just maybe you just want a precedent document. So you pay for the precedent document, we get it all for you, it's packaged up, here you go. Then you could manually make your edits, deal to deal or investor to investor. And then just before you and that investor would sign, you would have them take it to their own lawyer, and then their own lawyer would do ILA, independent legal advice. They would review it. They would say, okay, this is what you need to know about these provisions. Is this how you want this to read? They would give them independent advice, basically.
Hi,
Okay.
I have a question. Hi,
Yep.
everyone. Hi, Ryan. Hi, Diana.
Hello.
Thank you for creating this Zoom meeting. It's so nice of you. I have a questions with regards to a working partner. So I am not on the title, but I don't want to put a lien on the property. So, and can you explain more on the declaration of trust?
Yeah. So if I understand your situation correctly, you're the working partner. You're not the one that's registered to the title, and you're not the one registered on the mortgage.
Yes.
Okay. Yeah. So as some of you may or may not know, in Ontario, as gentleman is expressing, only the people that are going to be on the mortgage can also be registered to the title. So they have to match, or the land registry office will reject the registrations. So they have these money partners, which typically are the ones that go on the mortgage, and then the ownership. And then you have the working partner, who's like the day-to-day partner and managing the property, the tenants, the rent to own, the renovation, the whatever, right? So with that partner who's not on the title, the common question we get from real estate investors is, well, they could just go and sell the property, and then what do I do? I'm chasing them for the money unless they honor the terms of the JV agreement, if we have a JV agreement, right? And it used to be allowable. It's no longer that you could register JVs to the title. So you can't do that anymore because the land registry, the director of titles, will not allow JVs to be registered to title anymore. So what you have to do is you have to have in the JV, or sometimes people have separate out of the JV agreement, they have a trust agreement. And this trust agreement is a legally binding document. Unfortunately, it's not registered, but the trust agreement basically states Ryan Carson is the owner of the property. He owns it 100%, but he owns it in trust for 50% Ryan Carson and 50% Diana. And so that means Diana and I, even though I'm the only registered owner and the only one on the mortgage, are actually the beneficial owners of that property. So at the end of the day, there is, whether you have a JV and a trust, or you have the trust wording within the JV, like we incorporate ours all within the JV agreement, but you can do them separate. But the bottom line is that trust agreement creates another layer of contractual obligation between the parties, that if they did just go sell the property or refinance it or whatever without your consent, and they were trying to threaten not to pay you out or give you money or whatever they're supposed to do, that agreement allows you a legal foundation to bring a claim against them, to say, you're breaching our agreement. If we don't get this sorted out, I'm going to have to take you to court for what you owe me.
Okay. Yeah. Thank you.
I mean, and then the other aspect of it too, sorry, just to add in, is some people use a trust agreement as well for land transfer tax, for future transfer and or tax planning purposes. So there's very few exceptions to land transfer tax. And if you don't know, land transfer tax is the tax you have to pay when you buy a property. It's levied by the government of Ontario. And if you're in Toronto, you have to pay one for the city of Toronto as well. So there's double for Toronto properties. But if you, when you acquire the property and then you wanted to subsequently transfer it maybe to another business partner, maybe that's part of your transfer arrangement, or between the different partners, you wanted to transfer title for whatever reason. If you have a trust agreement set up that says Ryan Carson is the trustee holding it in trust for Diana and Ryan, and then down the road, Diana did want to get added to title, if we didn't have that trust agreement in place, adding Diana to title is going to ding us again for land transfer tax. So if we do a trust agreement, and then I add Diana onto title, I don't have to pay tax on that transfer because I get to put a statement in the deed that says I'm moving it from trustee Ryan Carson to beneficial owners Ryan and Diana. So
Would that affect as well, Ryan, if I own it in a personal name and then transferring it to my corporation?
So you have it in your name and then you want to move it to your corporation?
Yes.
Yeah. So if you did a trust agreement, that, and this is generally speaking, if you did a trust agreement, or some people are putting in the chat, trust acknowledgement, trust declaration, I would likely say they're probably all kind of referring to the same document. I would have to see the document to verify that, but let's just, for the interest of the group that's got the chat going here, trust declaration, trust agreement, trust acknowledgement, they're probably all the same legal document or having the same purpose around them. But in your situation, you've got yourself owning the property and you might want to move it to your company. If you have this trust agreement in place that says you personally are the trustee for your company and your company's the beneficial owner, then the benefit is down the road when you want to put it into your company name, that transfer between yourself and the company will be exempt of the land transfer tax.
Okay.
Now, this does not in any way exempt capital gains. So that you would have to talk to an accountant about, but this is a way of hopefully mitigating some additional land transfer tax, which is always fun to pay.
Thank you.
Ryan,
That was very good. That was a very good question.
hi Ryan, how are you?
Hello. I'm good,
And
thanks.
thank you very much for this insight about the JV agreement and the trust agreement. I would like to know about this while you are developing a JV or a trust agreement, whether you require two lawyers for the both sides, or do you recommend only one lawyer can do for both the parties? How does that work exactly?
Yeah, so as lawyers, we can't. There's limited situations where we can act in what's called the joint retainer, where we act on like both sides of an agreement, because by the very nature of it, we become in opposition of one another, right? So I always recommend the person who's our client would be typically yourselves, the real estate investor, and so we would act for you and give you the advice on your side of the deal. That way we can give you your own independent advice. You can ask us independent questions. We can give you independent answers. You can feel free and open to discuss anything you want or need. And then that means they need to have their own lawyer so that they can do the same. And only by there being two lawyers can you say there's been independent advice. So I think, if you're going to get lawyers involved, then it makes sense to make sure each party has their own, because then if stuff got really bad, bad or ugly, and you had to actually go in front of court or an arbitrator, the first thing you'd be able to say is, well, he had his own lawyer, completely independent. I had my own lawyer, and everybody discussed it and took time to do it, and then we signed after. So if you share a lawyer, then the problem you have is you couldn't use that kind of response if you were in front of a judge or an arbitrator. And the lawyers kind of putting themselves in a situation of really being, I don't want to say incompetent, but there's going to be they're going to be incomplete in the sense that all I can tell you is this is what the agreement says. I can't. If you ask me a question to say, oh, is that good? Is that a good clause for me, or should I have that in there? I can't answer that, because that would then be giving you independent advice that could be prejudicial to the other person.
So you said that we should always have a two-lawyer system. That would be a better, so that we can get an independent advice from both the side. And if there's a back and forth, then also it is always good to have all the points discussed prior to the agreement, right?
Yes, conservatively speaking, I think that's your your best approach to the investment. Yes.
Okay. Another thing is like in terms of trust agreement, suppose we bought a property about a year ago and now we would like to transfer it to the corporation. Is that a possible to make trust agreement in current situation, or it has to be done at the time of buying of the property?
The agreement should be done at the time you go on title.
Okay, so no backdating is allowed for the trust agreement?
Yeah, you should only be doing it from a present time forward. So if you were doing a deal today, you put that trust agreement into place, and then down the road you could use the trust agreement to do a future transfer to the beneficial owners from the trustee without land transfer tax. But you wouldn't be able to just apply the trust agreement retroactively. I think, well, could you do it? Yeah, I guess you could backdate it, but if you do, then you run the risk on an audit of, the land transfer tax people in the Ministry of Finance saying, well, that wasn't existing, prove to us it existed before. They might call you on that, and in that case, not only would you have to pay me the land transfer tax, but you might get slapped with some sort of penalty or fee, right? So so the answer is, could you backdate an agreement? Yeah, I guess you could, but you run the risk of the finance department of land transfer tax calling you on it, and then it's a question of, can you prove that you didn't backdate it, right? So the prudent and most important, appropriate way to do it would be just put them in place as a precaution. So moving forward, you have that option available to you. The other thing I should mention about this too, you need to make sure, you've probably heard people say this, or if you've seen me speak at different investment groups, I always say make sure you have a good power team. Power team being like lawyer, accountant, tax advisor, mortgage broker, home insurance representative, real estate investment coach. Like, those are your key players. You need to make sure, if you're going to put trust agreements in place, you need to make sure that the mortgage rep knows, and that the mortgage rep makes sure that that is not an issue for the lender. Because a lot of lenders are now asking lawyers the question when the lawyer goes to register: is there a third party who has beneficial interest in this property? And if there's a trust agreement, then we have to say, yes, there is. And if they don't know about that ahead of time, or expect that, and have approved this mortgage funding on that basis, then that might scuttle your deal, right, at the last moment. So you need to make sure that the mortgage rep that's helping you is aware that there is going to be somebody who's a third party beneficial owner who won't be on the mortgage and who won't be on title, so that they can make that disclosure to the lender they're choosing, so that the lender doesn't turn around and say, what's this all about?
And do we need to register this trust agreement or JV agreement with the court, or it's just a piece of agreement? Keep it without registration.
Yeah, unfortunately, I mentioned it a bit earlier. The JV agreements, trust agreements, those kinds of documents are no longer registrable. You can't actually get them registered and certified in the Land Registry Office of Ontario. Mm-hmm. Now, I think you can in other provinces. I'm only licensed and practice law in Ontario, so I can't give you that certainty or information for the other provinces in Ontario. But I think Alberta and maybe BC potentially allow the registration, but you'd have to seek that counsel from a lawyer out there, because I know they do things a bit differently out west. But in Ontario, they do not allow it anymore. So it's unfortunately it just becomes a legal contract. So something you just have to hold on to in your record keeping. And then as a party to that agreement, you just have to do your best to abide by those terms. And then if you feel the other parties are violating the terms everybody's agreed to, then you need to, you need to try to assert your rights by bringing it up to them that you think there's been a breach. If they don't rectify it, then you have your recourse. In normal days, not in COVID, but in normal days, you could make an application to the court and seek their opinion and get an order that in fact your other parties and partners have breached the agreement. Right now, I don't know, people probably know, but the courts are pretty much closed still. They're only taking emergency applications, which mostly deal with like a lot of like family law stuff, like custody issues and stuff like that. So the courts right now are pretty much frozen.
All right. Thank you.
You're welcome. Thank you.
So I think Marco has a question now.
Yeah, hi. Thank you, Diana, and thank you, Ryan. So I'm just wondering is there a certain timing within which you need to sign these types of agreements? So, for example, if you're the money partner and you're buying and you're putting your name, you're closing, should me as the working partner, should the two of us have something in place before she even purchases it, or how does that work, like that timing?
Yeah, I mean, great question. I would say the sooner the better. I would try to have your JV agreement in place before you start going shopping on all the deals and start flushing out all the exciting stuff of like, the renos and all this kind of thing. Or, the rent owns. I think it makes more sense to get it all in place ahead of time, because that becomes your foundational agreement, right? And everything will be based off of that. So if you know that you've got all your terms in place, everybody's agreeing that, okay, you're going to do this, you're going to do that. At the end of the day, we're both going to get this out of the deal. Then once it's all in place, then it makes it a lot safer. I guess if I can use a conservative word, but it makes it a lot safer and more fundamentally certain that you can move forward, because it's very clear. Okay, Marco is doing this in this joint venture agreement, and Ryan Carson is doing that. Otherwise, if you just kind of talk about it and you're excited and you move forward with the shopping and buying properties and start hiring trades, well, what if all of a sudden I come to you and say, well, wait a second, why are you hiring the trades? That's my job. But now we don't have anything in writing that says, oh, this was what you were doing and this is what I was doing. So I think if you can help it, it's always best to do it first and foremost, make it your fundamental document, then go out and start doing, if you agree in that JV that you're going to try to do up, 2 to 3 properties together. And this is the scope of the properties. They're going to be duplexes, or they're going to be single family, and we're going to convert them to duplexes. I'm going to be the one that goes out and gets everything arranged with a mortgage rep and a realtor. And then once that's squared away, you're going to be the person who goes and gets the person who does all the work converting it from a single family to a duplex. And we're both going to split proceeds 50-50 after usual costs and expenses, something like that, right? If you have that all in place first, then again, if while you're going through the process, something happens, maybe it's a minor thing, but maybe it's a more serious thing. If you don't have the agreement, then it's going to be he said, she said.
Mm-hmm. And when you're dealing with a JV contract, is there some way that the person on title can be notified that, for example, the person decides to sell their property?
It's a great question. There's not going to be any automatic notification. So when that question usually comes up, my best answer I can give you is typically the people that are registered on the title are the money investor, and other than them putting up the money and putting their name on the mortgage and the ownership, they really have nothing to do with the deal. They don't talk to the tenants. They don't talk to the trades. They don't do anything with the property. They probably have never even seen the property, to be honest with you. They just saw the deal. They thought these numbers look good. I want to invest. I like Alex. He seems like a good guy. He's professional. He's gonna be a good good partner to be with. So a lot of times they don't even see the property, right? And so at the end of the day, I think the best thing that you can do if you're the person who isn't on the title is, number one, make sure you have a good JV agreement. Make sure you have the trust agreement if it's not included in the JV. And then just make sure you're very diligent about managing the process and keeping an eye on the property. I mean, you're going to notice if something's happening, right? You know, there's going to be tenants in there. You know, if all of a sudden the tenants are moving out or something, or there's a sale sign, well, obviously those are dead giveaways, right? I mean, is it possible that somebody could do something privately and none of those things would be there? Yeah, of course. So I guess another like proactive thing you could do is you could have a lawyer run a title search for you if you suspect anything. The other thing you could do is if you have a realtor on your power team, or see, we use TerraView because we have to do title searches all the time for our title searching software. But realtors actually have access to a program that's similar, but they call it Purview. And so you might be able to just get an account with Purview and check title, you know, as frequently as you want. You just have to run the property. You pay the fee for the Purview to go through, which is probably less than $20. And then you can see, okay, yeah, nothing happened. Nobody's changed title. They haven't registered any other mortgages or anything against the property, all that kind of stuff, right? But unfortunately, there isn't any way just doing a JV or a trust agreement of putting anything on title that would then force lawyers who are doing a title search to trigger like your awareness of something. So the only other thing you could do, but then this goes back to my thing about financing and making sure you have a good, you know, mortgage rep, is you could register like a charge, like a mortgage against the property, because then you would get notified if there was going to be a sale or a refinance of the property. But now you've got to make sure that if you register a private mortgage against the property, it doesn't scuttle your primary finances. So
That's really interesting. Wow, that's really good. This is all very good information. I think Debbie has a question. Oh, you're muted. Sorry, I always mute everyone because there's some background noise. Let me unmute you. Oh no, you're good. Debbie?
Sorry, can you hear me?
Yep.
Okay, Ryan. Just something you said a few minutes ago about making sure that your mortgage rep is aware if there's a third party that. So if someone is qualifying for the mortgage and they're the only one that is qualifying for the mortgage and will be the only one on title, but they intend to have a joint venture agreement with someone else, are you saying that that should be disclosed to the mortgage rep, that there is going to be a joint venture agreement with another party who's not on the title or on the mortgage?
I think you need to make sure that, yeah, you've got a mortgage rep that you know, has your back and you have confidence in them, that you can have open discussions about that kind of thing. Because I mean, they're working for you. They're, you know, the lender they choose, I mean, is who they choose, you know, after you guys have had your discussions, right? The tricky part lawyers have is lawyers are not only retained on residential transactions by you, but the bank retains the lawyer as well. So we cannot not disclose something material that would be adverse to the bank's instructions. So not all of the banks, but a good number of them now are asking the question on our report to them, which is there a third party interest in this property? And if there is a third party interest, which would be like your beneficial owner, your trust agreement from a JV, then that would have to be disclosed in that statement, right? Because there is somebody who has a beneficial interest in the property. Because it's not just Ryan Carson owning the title and having the mortgage 100%. It is on title, like on the registration, but Ryan has agreed with Diana through trust agreement that Ryan actually only owns 50%. Diana actually owns 50% as a beneficial owner. So as you can probably imagine, the bank's like, wait a second, Diana has an interest in this property. We don't know anything about Diana. And now Diana technically can make a claim over 50% of this property, which we feel we have 100% claim over. Like they expect their loan to cover 100% of the property because I'm 100% owner. So that's where like that's why they're asking that question, right? So now some of the banks won't care, right? Like some of the banks are pro real estate investor, and your mortgage rep will have a very good working relationship with them, and so it won't be a big deal, right?
Okay.
Maybe the bank won't even ask about it. Like, I'm not saying this to scare you. I'm just letting you know that you probably want to have that discussion with your mortgage rep, because they're the expert on that side of it, right? They're the ones qualifying you, try to get you a deal and get you the money you need for your deal. But you don't want it to get to the lawyer and the bank asks the lawyer, can you report there's no other third parties? And then I have to say, but there is.
Mm-hmm.
And then the bank's like, well, then we're not giving you the money, or we need to know more about Diana here. Like, who's Diana all about?
So is there a way around that?
Like, can you do the joint venture? I mean, after, like,
So, so at the end of the day, I see this as being recorded. So, so yes, I mean, you could go and like if we use the example as Diana's my client, she comes to me, she's going to buy the property. She hasn't told me anything about a JV agreement, nothing about it. All I know is Diana is buying this property, going on the mortgage, going on the ownership, and that's it. Then I guess you could at that point have the JV done later, right? But then we go back to, I think, a question somebody else asked earlier, which is what's the best timing of the JV to get it in place? Well, you should usually do it before. It should be your first document. And then the question or the concern might be for you, not so much for the lawyer, because this example I'm going to give you is you say on a sworn document there's no third party interest. So now under a sworn document, you just lied. Mm-hmm. Right? So that's the risk you run. So I guess, again, you could do that, but does that create a whole other set of problems for you if anybody came to light of it, right? You know, 9 times out of 10, probably nobody's checking that, but you don't want to be the 1 in 10 that somebody checked it, and then the bank says, well, wait a second, who's Diana? What's this all about? What's the JV? Right. Why does she have a trust interest? Why is she beneficial owner? And we got a document in our file here that said beneficial interest. Mm-hmm. So you lied on a sworn document, you lied in your application, and now we don't own all the property. Like they could say you breached the agreement, and now you're in default. You know?
Yeah.
And
but
so,
I mean,
so that's why because you have the benefit with a hired, you know, mortgage rep, somebody that's working just for you, because I do not believe you have to ask the mortgage rep, but I don't believe they're in the same situation as the lawyer. Like they're not jointly retained by the bank, so they're just retained by you. And if that's the case, then the good part is you can have open conversation with them and just say, okay, so you know that, you know, Marco and I are real estate investors. We are using other people's money to help us, you know, buy these properties. We manage them for them, and then they're on the mortgage and the title. But, you know, our lawyer recommended that we, you know, have JV agreements and trust agreements. So we want to have those in place. But we want to make sure that we aren't using a lender that's going to turn around and give us an issue of asking a question, are there third-party interests? We have to say yes, and then the deal gets scuttled. We want to make sure the lender knows this is a real estate property, which they're going to have to know, of course, that it's a real estate investment property, because ask in the application, do you live there? You're going to say no, and you're going to probably use as part of the mortgage application investment income. So they're going to know that it's investment property, right? Of some sort, if it's a rental, right?
Right.
So, you know, that's easy. If it's a buy and flip or a burr or whatever you're doing, I mean, again, they should probably know, because you're going to say it's not a primary residence. They're going to know that it's investment of some
Right.
sort. So, you know, I think you're safe to have that kind of conversation with your real estate mortgage agent. If they say at the end of the day, yeah, we work just for you, we don't work for the banks, you can ask us any questions you want, and and let's make sure all the cards are on the table, and we make sure we get you a lender that's not going to have any problem with JV, everything.
So we have a unique situation. Let's say we already, let's say, have a mortgage approved with a bank, with an A lender bank.
Yep.
So and there's potential that they may not like it if they ask the lawyer, and the lawyer knows something. But if the lawyer knows nothing, then everything's okay, right? Because
yeah, I
then
mean,
he knows nothing.
I guess I would go back to what we said before, which everything would be okay for the lawyer who's acting for you and the bank, because if they honestly don't know anything from you other than you're going on the mortgage and the deed, and they don't know anything about JV or third party or anything like that, then they can honestly report that this is what I knew and this is how we dealt with registering the document. But if there's a statement in the paperwork that you're signing that says you swear that there is a third party, then that's where you have now maybe an issue.
Okay.
Yeah.
Okay.
Again, I don't know if it would ever come to light. Probably 9 times out of 10, probably it wouldn't, because the bank really does not. They don't care unless you're not paying their money, right? Like if you're paying them your monthly payments, and you got the place insured and your property taxes are up to date. I mean, banks, as far as I know, are not routinely going around auditing deals. Like, is there a third party involved here, right? Like they don't typically care about it. Again, I have not worked for the bank, so I don't know if that's wrong or not true, but I've never heard anybody say they got audited by the bank and they were completely in good standing and they had never done anything wrong, and then they found out they had a third party, right? I mean, it's only going to become an issue if there's some alarm bell for the bank and they start poking around in the deal to say, like, who's this person, right? Like,
Right.
so, if
Thank
you
you.
got in good standing with the bank, it's probably not going to become anything. But where I guess the main reason I was bringing it up is I wouldn't want you to do all your hard work, get it right to the finish line of registration, and then the lawyer can't get you registered because he
Right.
asked you, we got an issue today
Right.
with a third party. That's more of the reason why I brought it up.
Okay.
Thank you.
One other thing maybe I'll just bring up as an aside, Diane, just because it's actually we're dealing with a real estate investor right now on a particular scenario. So maybe I'll just bring this up for your group because it might be something that comes to light for some of you. A lot of banks are starting to throw in a term to their mortgage that says you cannot have second mortgages registered against the property.
Oh.
So if you're using alternative financing to leverage properties for future deals, I mean, which is pretty common, you would be doing what my client's doing right now, which is he has about like a dozen properties. He's taking one of his properties, putting a second mortgage on it, and then his property that he's buying, the first mortgage will be a first on that property, but then collaterally registered as a second on another property. So the issue is this other property, that's the collateral. When we have to write to the first mortgage, which is a bank, all his banking is A, right? This A bank came back and said, it's a term of your mortgage. You are not allowed to have seconds registered against the property. So now this deal that he's trying to do, which is Tuesday, we have to go and find him a new lender because this lender won't, we cannot get the deal to go through on Tuesday with this lender because they won't move forward without the collateral property as security. And there's no, like, all his other properties are all with the same lender. So they all have the same term. So we can't get the second mortgage, like we can't get the second mortgage registered to any of the other properties. So when you're negotiating again with your mortgage rep and you're doing future deals, make sure your mortgage rep gets in writing from the lender that there is no prohibition to second mortgages.
Wow, that's a really good tip. I didn't know about that. So it's really good to keep in mind.
Yeah.
Are you okay for one more question? Hopefully, Trami, it's a short one. Are you
Sure.
okay for one more? Yeah. Okay.
Yeah, one more.
Trami?
Sure.
Oh my goodness, I've been trying to raise my hand, but I guess clapping because they don't have a hand raising thing icon here. But
I did see you clapping. I thought you were just cheering me up.
Motivation.
that too. But yeah, thanks Deanna for setting this up, and Ryan Carson, like he's great. I would encourage everybody to reach out to him. He's actually helping me with an acquisition that I'm doing now, and he does my wills and stuff like that. So he's awesome. So with my recent acquisition with a partner, this person is a money partner. They're going to be passive, and we have this mutual understanding that they're going to be passive because they don't understand real estate as much as I do. So we're doing a corporate structures. They're 50-50 shareholders, and I'm a 50 shareholder. So I with this whole JV agreement in place that you're talking about, now that they're not letting us register it on title anymore and all this, it becomes a little bit convoluted, doing it this way with the JV agreement and all that stuff. Like, where do you draw the line that that we do a corporate structure versus a JV agreement? Like, when would you do one versus the other?
Yeah, well, it's a great question. I don't know if 8 minutes will be enough time to answer that. But I mean, first of all, it probably really depends on the tax advice, right? Because obviously you guys are setting up your real estate investing businesses to make money and hopefully make as much money as efficiently and with as little tax as possible, right? So corporate structures usually 50% driven by what's the best tax approach to this problem, right? So that is one, that's probably the first thing to figure out is what's the tax advisor saying is the best way to go about this partnership, this potential real estate venture. Is it through corporate structure? Is it through JVs? Which is better? I think I always point my clients to the accountant first, because until we know the accountant's feeling on the taxes, it's hard to just talk about the corporate without the tax. So once we know the tax, and let's say they said it doesn't matter, you can do either way, then I think it becomes a question of, okay, well, how's the financing of this deal working, right? So again, it goes back to talking with your mortgage rep. I have some clients who they don't want to be on any mortgages or deeds at all. And if you do a corporate deal, so everybody's a shareholder in the same corporation, and that's how you all partner up. You just stay all in the same corporation as opposed to separate businesses as a JV. Then you'd all be in a shareholders agreement. And if you do that corporate structure, then the mortgage rep's probably going to have not only the corporation as the borrower, but then all the individual shareholders as guarantors of the mortgage, which then kind of brings you back to the problem of why somebody didn't want to probably be on a mortgage in the first place. They just don't want to get tied up with mortgages against them. Now they're the guarantor. So if that were the case and the shareholders didn't want to get tied up as guarantors, then the corporate structure probably isn't maybe the best fit, and you'd want to concentrate on the joint venture structure, which is, hey, I'm going to be the non-money partner, I'm managing the property, I'm the expert at like real estate and real estate investing, I'm going to stay off the ownership so I don't get bogged down with a mortgage. But I'm going to manage it. I'm going to take care of it. I'm going to find all the tenants, find all the trades, do all the renos, do the flip, coordinate with the realtor and the mortgage broker. You, as my other partner on the JV, all you need to do is have good credit so you can qualify for the mortgage when we get it approved, and go on the title, and then just sit pretty until we get to the different phases of kicking out capital. Did I answer that right for you, Trami?
Yeah, it comes down to the guarantor, if whether or not the active partner wants to be part of personally guaranteeing the property or mortgage.
Yeah, absolutely. Like most of the time people like JVs because the one person who's the non-money partner, they don't want to be tied down on a mortgage, right? I mean, that's most people on this chat are probably going to nod their heads and be like, yeah, we're the non-money partner because we don't want to be on a mortgage. We don't want to get tied into the mortgage. But then your risk is, oh, there's nothing that triggers anything to title to make sure people know that I have ownership in this thing, right? It's this unregistered JV, this unregistered trust agreement that I have to just try to police myself. So if you're the investor and you don't mind having yourself tied to a mortgage, then I would say do the corporate structure all the day.
But the only thing is, though, my understanding is if it's registered, the property is registered under the corporation, and let's say, I go out and purchase a property on my own, and apply for a mortgage, that's not going to show up that I'm titled to, X company, because I've acquired that property through X company. It's not under my personal name, though.
Yeah, so you're right. So like when people do a search, it's going to say XYZ Inc. owns the property, but they could do a public search of XYZ Inc. through the Ministry of Consumer Affairs and see who the incorporators are of the company. Like that is public knowledge. The shareholders won't be at the end of the day. Shareholder information is not public knowledge on public record, but the people who incorporate are.
Okay, I guess if I'm applying for a mortgage and they would ask how many corporations I'm attached to, then they would search that corporation, and that's how I would get tied up that way. Okay.
Yeah, and so if you're talking about like how does the mortgage company know, how do the banks do that kind of thing, they're gonna just like in a regular mortgage application for you individually, they might ask you for like your NOAs for tax purposes to prove income and all this kind of stuff. They'll probably do similar things with a corporate borrower. They'll be like, you need to give us like a certificate of incorporation. We need a list of all the directors and officers and shareholders. Like they'll ask you for those sorts of things as part of their due diligence typically, to see like who's all involved in this company. So then they can make sure that they've not only got the guarantee of the company itself as a borrower, but they'll typically want all or most of the shareholders to sign guarantees.
Wow, thank you so much, Ryan, for all the information that you've provided. I feel like all of us have like a lot of research that we need to do and make sure we fully understand everything. So would you like, because I'm pretty sure everyone's going to want to contact you, and because you know so much about it, and would you like to provide your information?
Yeah, I'm just actually putting that in the chat right now with my email, so people, because I know there's a couple questions here that people have raised that maybe talked about, but maybe not. So I've just given my email here and our website, and yeah, so feel free to get in touch whenever, anytime.
Yeah, thank you so much. So it's ryan@carsonlaw.ca.
Yes, that's it.
Perfect. Yeah, I'm pretty sure a lot of people are going to want to contact you. Thank you so much for all the information you provided us. I
You're
think
welcome.
everyone is really happy, and like that, people have been already asking me for for the recording. So
Perfect. Okay, well, thanks, guys. Anytime. And if you want to have me back on, Diana, just let me know. And if there's specific questions that have come out of this, then just let me know.
yeah, for sure. I think this will definitely happen. I think there will be follow-up questions for sure.
Okay. Thanks, guys.
Awesome. Thank you so much. Bye, guys. It was really good having everyone
It was
here.
great.
Bye. Thank you. Have a good time.
Thank you, guys. Thank you.
Thank you, Ryan.